All right, hello everyone, and thank you for joining today's presentation brought to you by the SLW Institute, which was developed by the Schwegman firm to deliver educational and training content to advance your IP knowledge. My name is Brian Nuss, and helping facilitate today's webinar. Before we begin, a few housekeeping items. If you have any questions during today's presentation, we encourage you to use either the Q&A or chat feature. Also, I'll be sending a follow-up email to each of you that provides a link to today's recording of the webinar and a copy of the slides. For today's presentation, we have Liz Fortier and Mark Stignani here to talk about the latest developments and beginning the conversation around continued obligations with GDPR, which was in force since last Friday, May 25th. Liz and Mark, I'll let you introduce yourselves and take it from here.
Hi, thanks for having me here. My name is Liz Fortier, and I have my background is 25 years of experience acting as GC for technology companies here in Minneapolis. Right now I am GC and a data protection officer for a company called Lucid. I also, in my spare time, have a law firm where I assist with data privacy and information security consulting.
Hi, and I'm Mark Stignani. I'm a analytics chair and compliance officer here at Schwegman. Prior to my Schwegman time, I was over at Thomson Reuters, in which I did a lot of technology, IP law, and some data security law alongside of that. Just as a housekeeping item as well, this is a follow-on presentation to an earlier presentation on GDPR and IP. This is meant not to repeat that, but to follow on top of that. So for those who did not get to that presentation, there will be a link in the follow-up emails containing that presentation as well. So the slides will be available for anything that we may have not covered it on this time through. And with that, let's kick it off and talk a little bit about the GDPR and the whole continuing obligation aspect to it. In general, the GDPR, as all you may remember, this is about taking and protecting the personal data of EU citizens. There are a number of items in which I will not go through and read, but everybody should be able to be aware of these things. We required changes to privacy notices. It requires a streamlining of the way people can opt out of having their personal data used or erased, for that matter, without an undue delay. And to get that across, they have very, very large fines. How large fines? Well, right now it's about 20 million euros as the minimum amount, or 4% of your annual sales, which is whichever is greater. Now, Liz has attended a number of sessions with various countries' DPAs. So Liz, if you could give us a little sense for how serious the DPAs are in those marketplaces.
So about a month ago, I was at an IAPP conference over in London, and a bunch of the heads of the ICO offices over there and the DPAs spoke. And it was interesting to hear their different approaches to how they would enforce how they're going to approach enforcing this law. I think Ireland for sure was very aggressive and said, right, we are going to be fining people and they're going to be significant, which is one extreme. Elizabeth Denham spoke at this conference and she was a little bit more diplomatic. Her quote was actually that they're focused on protecting citizens and consumers. And her view was that those organizations that persistently and negligently ignore the law will be fined. Although in her opinion, money fines are not always the most effective tool. And so I think it really, you have to, it'll be interesting to see, but I think it'll be a country by country basis to see how aggressive they are in enforcing these laws.
Now, one thing you had mentioned to me was the size of the budgets. I believe it was Elizabeth's.
Elizabeth Denham spoke, and she said currently her budget is 24 million pounds, but it's quickly in the next year going to be going up to, her budget will be going up to 38 million pounds, which is, I think, pretty staggering.
Yeah, and I think also to look here, the quote out of the Austrian DPA is they think that the grace period is already expired. So one thing, as we'll talk about later, is that there have been a couple of complaints filed already out of Austria against 2 American companies. We'll cover those in a little bit here, but that's not the only thing. Fines aren't the only playground, as Liz had mentioned. There are a number of sanctions that are non-monetary. There are basically orders to halt data processing. So you can imagine if you're an ad tech company or a company which does an awful lot of data or personalization, the order to halt your processing would be certainly significant, even more significant than maybe a 20 million euro fine. They also have the opportunity to taking actions against your processing partners or your co-partners or co-controller partners as well. So their ability to interfere with your business operations, I think, should not be underestimated just with a fine.
No, and I can say for those over in Europe, they were very focused on the order to halt data processing. They seem much more afraid of this, quite frankly, than the fines. And for those of us who have presence in the US, we may think that we're immune from this, but as it says here, I think you need to focus on the processors or potentially joint controllers or partners or perhaps subsidiaries or affiliates that you're reliant upon over in the EU, where if their processing activities are halted, how that would potentially impact your business. So I don't think we can just assume that we're immune from this just because we're sitting in the US.
Yeah, thank you, Liz. And I think a lot of the things that we should be taking away from this is that they have ample opportunity to generate revenue, especially in markets that don't have the strongest economies, so that there may be an incentive actually in some of these DPAs to make this a true and sincere profit center for their marketplace as well. So with that in place there, I hope we haven't scared anybody too badly yet, but let's talk about what's happened since Friday. Literally on Friday itself, there were complaints filed against Google related to its Android system, and then against Facebook for Facebook proper, Instagram, and its WhatsApp app, respectively asking for 3.7 billion or 3.9 billion euros in potential for fines there. This was filed out of Austria, as I'd mentioned earlier, and their theory is that these parties are forcing consent, in the sense that forcing people to opt in and provide their consent to using personal data to use these systems, which I believe is a fairly novel way of thinking about this. But it's also I think it certainly is in the spirit of the protection of the EU citizens' data as well. So more to come on that. So that's those complaints are 2 days old. Now, Liz had mentioned that Facebook was also filed on by a company called Surveillance Capitalism. And could you give us a little flavor on that, Liz?
Yeah, listening to a professor actually from Henley who was speaking, and he has a friend apparently who is a prosecutor in California. So this would have been about a month ago, and he said just 2 days earlier at that point, his friend had filed a class action lawsuit, and the basis for the claim was surveillance capitalism, and it was filed against class action lawsuit against Facebook. So I honestly don't even know if this has been made public yet, but I heard about it over in London. I thought it was sort of a fascinating take on what's going on with Facebook and just this notion of the interrelatedness of data and how our actions are going to be viewed. And I think this will just be, I won't go into debate or explanation of surveillance capitalism. Go look it up. It's really fascinating, but I think just something interesting to think about.
Absolutely. And there was a number of companies that did a duck and cover. They either stopped operations or withdrew or turned off their services or are banning access by European citizens. So a number of these are companies that are doing things like optimizing contact leads based upon who's in your inbox, or allowing you to pull other people's pins, like the Pinterest Instapapers, to cut and paste other people's postings into your own kind of scrapbooking aspect. Tronc, which is the owner of many news entities, including the Chicago Trib and LA Times, basically started blocking EU citizens, as did the St. Louis Post. A&E also did a number of actions and its properties as well to really kind of eliminate, to the best of their ability, their exposure from an EU citizen standpoint. So that's one of the approaches. I mean, Liz, have you heard of anybody else, kind of ceasing?
Well, I have, right? So, but I also think there's a flip side of this, where there's also opportunity of this, because there are businesses who have been saying, well, yeah, this is, the burden is too great for our business, or we don't understand this, or we'd rather just not deal with EU data subjects. Too complicated for us. We don't have the money to deal with this. But I also think there's a flip side, where I've also seen opportunity come out of this for some of my customers, where they're like, well, we actually can take on obligations that maybe you as a controller don't want to manage. And so I actually think there's opportunity from this as well, from a product and a technology standpoint, if you really understand the law and think about it maybe outside the box. So I would say I'm starting to see that as well.
And there's even a couple other approaches I've seen as well. I think NPR is actually providing a plain text version of its news articles for people who don't want to opt in but still want to read news. So I mean, there's a lot of I think fairly interesting strategies for dealing with this, rather than simply putting the work in and getting a DPO in place and getting your audits in place and doing your homework. So there's a lot of companies just are trying alternatives to full compliance, as a lot of the European companies have seen. A number of companies have used this opportunity to just close shop. CloudPack, Cloud Core Social Media Analytics is kind of the whole basis of business there. Uber Entertainment and Ragnarok Online both had they killed their US servers. Some of them just shut down their online gaming platform simply because it was too expensive for them to refactor it to become compliant with the GDPR. Verve and another Czechoslovakian social network also have kind of ceased business. So the fallout's been immediate with this, whether it was because of GDPR or it was just a good excuse. I think there's been a number of interesting data points just in the last weekend showing people's reactions.
Yeah, I've seen a lot of action in the last couple days around the age, right? So Lucid is a market research ad effectiveness platform, and a lot of conversation around activities or that they, prior to May 25th, that arguably maybe they weren't handling it correctly before, but this notion of how are we going to deal with 13, 14, 15-year-olds is a big topic of conversation as well, right? Whereas maybe we weren't collecting any sort of consent previously, and now all of a sudden we want to talk to 13, 14, and 15-year-olds, and how are we going to do that, right? And right, this notion of what's verifiable consent is unknown, right? No one quite knows. So I think there's a lot of unknowns that companies, at least from my perspective, were trying to figure it out in real time.
Absolutely, and taking along the line of what is unknown, ad tech is, a lot of companies are just dropping their programmatic buying. I mean, this is something that, Liz, you mentioned you haven't quite seen in your company yet, but there are a number of articles where U.S. companies especially are really dramatically slowing down their ad buys and the amounts of revenue associated with that. So there's people warning between 25 to 70% of the ad buys are being canceled at this point until such time that they can figure out how that works. And Liz, you had mentioned that the ad tech is really divided, how that consent is being handled.
Yeah, so there's a lot of, Lucid has a big ad tech business, and there's a lot of debate around who's responsible for getting the consent, right? Is it the publisher? Is it the advertiser? Is it the third-party processors who are associated? And how do you get that consent when you're really dealing with ads? And I don't know that anyone's really solved this problem. We have not seen necessarily drops to these percentages, but I assume, who knows? But this notion of programmatic, and there's just in this industry in particular, there's just layers of how these services are performed, where they sometimes it's really fascinating about how they push sometimes payment obligations to one entity who's not necessarily involved, and an obligation on the company that's hosting the ad who may not even be receiving payment directly, and sort of the layers of who's involved in just to do the ad effectiveness and the programming and the hosting. And who's responsible ultimately for getting the consent, I think has not been worked out from my perspective. And there's a lot of maneuvering right now to figure out who's going to get it, who's going to be responsible.
Absolutely. And along that line, I just wanted to include some halls of shame aspects, or in my mind, which are so far big fails in how they've handled things here. I mean, Oath, which is formerly Yahoo, it owns Huffington Post, TechCrunch, and a bunch of other things, pushed out, in my mind, a very poorly organized and a poorly executed version of how to manage your privacy. And of course, the GDPR. I mean, there were 4 pages of interaction. It took me, I mean, it was almost as if we put Comcast customer service person in charge of how to opt out of this thing, because it took me 40 minutes to get through, to their opt-out page, opt-out of their 200 or more partners that had, automated opting out. Plus, there was a second opt-out page where you could push a button and have them opt out many of these various partners. But less than 50% of them worked when I was trying it. And then I tried it again, and less than 10% of the following worked after that. Then they followed up with a full page ad for some service at the end of it. It was horrendous. And just from a personal standpoint, I can't imagine how that's making the process any easier or easy to understand, or to request to be forgotten in that respect. So I hopefully they changed it substantially from Friday to Monday. But it's still a difficult process.
I would say there's probably going to be more confusion before clearness on this, because I was telling Mark earlier that I already had a complaint that a consent wasn't translated into German, the German language, and so therefore they didn't think it was an appropriate opt-in consent because it hadn't been translated, and complaining about what was in the consent versus what had been included in the privacy policy and the cookie policy and terms. And so I think there's going to be a lot of debate and back and forth about how to effect a proper opt-in consent.
Yeah, it keeps compounding. I mean, they pulled this up this morning. Somebody sent a picture of their refrigerator, which has a smart appliance aspect to it, and here is Samsung's attempt at having you opt into a privacy policy on a refrigerator, and that the whole IoT aspect I think is a giant unknown factor on this as well. I mean, it'd be interesting to see where Alexa and some of the other listening devices that are being sold out there is where how do you actually get notice on my smart TV certainly hasn't given me notice of GDPR compliance at this point as well. Another aspect is some of these companies, Razer, which does I believe hardware mouses, is noticing these people, if you don't opt in, then your hardware is not likely to work. Mm-hmm. Then there's a company that prides itself on privacy and data compliance. Gostrey just happened. They said sent out an email saying we got GDPR licked here, and then included 500 open unencrypted emails of people from the looks of the email addresses on here in Europe and all over the globe, just by themselves. So I mean, the level of oops and a lot of this stuff is these are just some of the first and earliest examples. There's going to be more and more of these as people try to stay, especially in the American sense, stay doing business as they would expect to do business, but also pretend to be in compliance or do their best to be in compliance without changing their business metaphor, which is, I think, a very risky thing at this point if you've got significant European revenues. Mm-hmm. So just a couple other things on general GDPR, then we'll move into Liz's slides on continuing obligations here. So, as I said, everybody in the world who has a European client, customer, or employee should be concerned about this. And also, if you're a law firm and you're selling services to any of these people, you certainly should be much more on top of your GDPR compliance than even a company that is just a standard one, because you've got different requirements from different clients, and you need to be able to say what's right and what is within your ability to service and what is not within your ability to service. Liz, let's talk about continuing obligations.
So this is just a high-level slide of I've outlined areas where I think we'll all have continuing obligations. One thing they continue to stress when I was over in London was this notion of that a guiding principle of each company under GDPR should be responsibility and accountability, right? Responsibility and accountability. And they really, from a European perspective, they really want privacy to be embedded in the DNA of our organization. So not, I think those of us in the US sometimes approach this as a check the box, done, right? Put it in a folder, I'm done, I'll think about it again in a year. And they really want this to be something that we live and breathe throughout an organization as we progress. It wasn't just a May 25th come and went, right? It's a how are we embracing this going forward? And so, right, each of these topics underneath the green circle, right, are things that we could be talking about: privacy by design, and how is that working in our engineering departments? Vendor management, how are we ensuring that our processors or companies that we're sharing personal data with, that they're doing the right things, right? I actually, there was recently a controller in France who was just sanctioned because the controller hadn't been formally auditing the activities of its processors, right? Which I thought was fascinating, right? How are we doing? What are we doing related to subject access rights? And how are we managing this? And and it's interesting. Those I've already seen. Oh gosh, we probably have had 10 requests come through since Friday, and none of them were rights to be deleted or erased. They were all rights. They were other types of rights, right? Rights wanting to know what we were doing with their information, so not total erasure, but other types of requests. Certainly the DPO has continuing obligations. I think we're all probably seeing, or at least I've been seeing, a ton of data protection agreements out there. I think those will continue. I would encourage you all to read them, because I've actually seen a lot that are not correct. I've seen, right, the obligations are incorrectly stated. Some that actually have the model contract clauses are wrong, where they've named the importers and exporters are not correct. So I think a lot of, they all have, the ones I have seen have not all been accurately drafted. So I would encourage people to actually look at them. I was telling Mark, I've actually seen a couple handfuls of requests for joint controller agreements, which to me is fascinating, because the concept doesn't even exist under the regulation. But I've had some pretty heated conversations with attorneys, in fact, who have said, look, I get that this doesn't exist, but I want it, right? So you're going to do it. We're going to define what we're both of our obligations as joint controllers. Certainly we have breach notification obligations, security initiatives, and training. And one thing I wanted to talk about related to training was some of the DPAs over in Europe said one of the first things they look at if they're going in and reviewing a company is to ask to see a copy of the formal training program for employees.
Mm-hmm. And I can certainly confirm that a lot of our clients are certainly asking for a lot of these same sorts of things here. One thing that we've been talking about as well is that a lot of times we'll see the controller try to push all of the obligations, responsibilities down to the processor. In our case, the law firm, and Liz has assured me that may be counterproductive to the nature and spirit of the GDPR. One of the things that we will see going forward is kind of a lot of companies take this one size fits all with their agreements, and we're finding in many cases one size fits one or two
Yeah.
in these agreements. One of the things I just want to throw out there for the listening audience here is that we are considering doing individual series in some of these bullet points, and would certainly want to hear from you whether or not you've got interest in that or not, because I mean, frankly, we could be talking for an hour or more on each one of these bullet points and the right way and the wrong way to do it. But I certainly wanted to make that aspect open and interesting for the listening group here.
As Mark just said, talking about companies and trying to figure out how to manage responsibilities on this, I was telling him that I'm starting to see a lot of DPAs that are, trying to push all liability, for example, onto the processor, or to have the processors indemnify the controllers for sort of all liability, and really try to push or shift the responsibility. And one thing that came up when I was in London was this notion again, if we go back to this guiding principle of responsibility and accountability, there was it might have been someone from the ICO from France basically said, in practice, they would view that a company should be considered less responsible if they're trying to transfer all blame or liability to a third party, which I thought was sort of an interesting concept as we're all trying to manage responsibilities under this law, that controllers and processors both have obligations and responsibilities, and if we truly are embracing the spirit of this law, we should all be owning and be responsible and accountable for our responsibilities, and not assume that we can just push that to a third party, which I thought was kind of an interesting thought.
Certainly counterintuitive to most of our American legal training.
It is.
We want everybody else to indemnify us for their actions.
So one thing I thought I would spend a little bit of time on, since we're not going into detail on these bullets in particular, I thought I'd spend a little bit of time on the first bullet that I've circled here, just because I think this is a fundamental construct of this law, and something that we maybe don't always fully understand or think about it in this way. And it's something we should have thought about leading up to May 25th, but I also think it's an important concept, and because it's something it's really isn't a continuing obligation post May 25th, and that's this notion of what's your lawful basis for processing, which is really the fundamental tenet of this law, in my opinion.
That's right. So
this is, we have sort of a person who's sort of fearful, this is supposed to be a fearful person, and I will tell you, it was something, this topic came up a lot in Europe. It's this notion of, should we be using legitimate interests as our lawful basis for the processing activities? And again, processing under the GDPR is pretty much almost anything, It really is any activity, storing, sharing, disseminating, deleting. It's pretty much anything, and you need to have, go next slide, this is the actual law, which is sort of, but you need to have a lawful basis when you're going to process any type of personal data of a European data subject, Mark had the slide earlier of who are we trying to protect. We're trying to protect European citizens and consumers. That's what this law is directed at. So the first bullet is you need to have a lawful basis, and that's not, that's something we all should have been thinking about up till May 25th, but it's also any new processing activities that arise in the future, So we all should have been thinking about all processing activities within our organizations, but it's also processing activities that arise in the future. And for every processing activity, you need to have a lawful basis. And most of those lawful bases require that the processing is necessary, which is an important, that's sort of the key word. You also need to be determining what your lawful basis is before you begin the processing. And it needs to be documented, and that's a really important point in this. So as I get into the different types of lawful reasons for processing, right, you need to do this analysis before, right? So there's something called, right, there's PIAs and DPIAs, which are your means for documenting your processing activities, documenting and recording your processing activities within an organization. And one of those bullets you saw was privacy by design. The concept behind that is really, again, injecting this into the DNA of your company so that you really are thinking about what those processing activities are before they occur, right? And that's really important.
And along that line, for the, especially with the IP practitioners out there, you can, many of you can probably empathize that getting IP injected into the development process is almost equally as difficult. So, you know, here's one more thing you have to inject into the development process, where you think about these things ahead of time. You got to think about, if you're going to file a patent application, you've got 2 inventors, 2 in Europe. Have you done your assessment? Do you have a lawful basis in place with their employment agreement or with some other agreement in place for them to file consent to have filing the applications in their place? More so importantly, when you get into investigations for trademark takedowns and things like that, you know, you should probably have a good thought process about what lawful basis you're doing your investigation under prior to that, because you may be, you know, stepping on top of GDPR in your own investigation work prior to any sort of legal opportunity or legal filing before a court.
But it's also, from an IP standpoint, it's also thinking about, right, are you embedding a new third-party component in your code, right? That's now is a new processing activity. Are you now saving data with some new third party? Is your data now going to be outside the US or outside the EU? Or so it's really thinking about all the different types of processing activities, what you're doing from a development standpoint, and what's that doing to the data, and the types of processing activities that are going to happen or that are going to arise as a result of those changes from a development standpoint. So again, right, just thinking about this before you begin processing, I guess that would be the one thing I would highlight here.
Okay.
So this is a...
Is it a build? No, it's not. Okay. Oops.
Oops.
There we go. Sorry.
So these are somehow at the top of this, these are the 6 lawful ways of establishing a lawful basis for processing. If you start at the top, it's consent. That's the one we're sort of generally used to hearing about. If you start at consent and you go kind of in a clockwise fashion, these are sort of organized in a specific order, right? I think if you start at consent and go clockwise, it's probably the most well-established or safest route of establishing a lawful basis. So certainly consent is sort of the easiest, the most certain, whereas legitimate interest is probably the least sure, least certain method. But I've highlighted the top 3, which are primarily for the main focus for B2B and B2C organizations, right? So opt-in consent, contract if you're establishing consent vis-a-vis a contract, or if you're relying on legitimate interest, are the 3 that are going to most readily apply to corporations. The other 3 down below, legal obligation, a vital interest, or some sort of public interest, are probably going to be less applicable for organizations.
And we've got a question in here, so I think it's appropriate we jump to that. Is generally it said we're in Canada and we've received a couple of agreements from annuity service providers located in Europe. Do we need to sign and send these back to them, or are these blanket emails that we are exempt from? And I really, it's not a question we can really answer. But I think you certainly need to look at, you certainly ask of those annuity providers, what data are you talking about? What data, what sort of data are you looking to do? Because a lot of, at least at our firm here, we're receiving these agreements, literally, here's something, sign it. And our general approach is to go back and ask them, well, what data are you talking about? And have them actually be relatively specific with us as to what sort of data they're going to be working with and playing with. I mean, if it's simply names of an individual, that's one thing. But if it's they're looking at our web browsing behavior and things that have no business being part of their business, no.
What I can say though is if it's a European business and they're sending you some sort of agreement, it might be a DPA with the model contract clauses, because they would be required as if this is a controller to processor relationship, you'd have specific model contract clauses for controller to sub-processor data transfers. So if you are, in fact, if your business is a processor to this entity, you would have an obligation to sign this agreement. If they are the model contract clauses, there should be somewhere within the language, right, there should be a description of the personal data that's being processed, right? Who's the exporter, who's the importer, how is the data, what data is being processed, how is it being processed? And so there should generally be language somehow within what you're signing that should give you some understanding of what you're being asked to sign. So to Mark's point, I would try to understand what it is you're signing truthfully before you sign it.
Yeah, and don't just ignore it either. I think there's so much blanketing of these emails at this point. It's very easy to feel like you could ignore them, but I really think, especially if you have any sort of contractual relationship or asset relationship with these companies, you should take them seriously and see what they're asking you to obligate yourself towards.
I mean, I can say, right, if we're receiving it as a processor, the first thing I do is say, okay, do we have a contract with this company? Right? What do we do for this business to try to get an understanding of whether or not I think we are conducting or processing any personal data on their behalf, right? So I sort of start with what's the contractual framework, because there is an obligation for there to be some sort of written agreement between controllers and processors. So you might want to sort of start with what's your relationship with these annuity service providers first.
Okay. So I'm sorry, just to interrupt there. Are you good with the slide or? Okay. All right.
So I thought it might be interesting to talk about legitimate interest. I think it's something that we may see more of. But I also can say it's something that, at least based on what I was hearing over in Europe, that it will be an area of focus for the regulators as well. It is the most flexible, lawful basis, but it's not always appropriate. If you do choose to rely on legitimate interest, you are taking on extra responsibility as a controller. And as I'll show on later slides, you still do have obligations related to how you're going to document those legitimate interests, both in your privacy policy and your own records. There are 3 elements to the legitimate interest basis, and it's really a 3-part test. One is to identify the legitimate interest, 2, to show that the processing is necessary, and 3, to balance it against the individual's interests, rights, and freedoms, right? Again, we're talking about European citizens and consumers. And so this is really a business and legal balancing test to determine whether or not the best way of ensuring a lawful basis is really based on this legitimate interest. And again, the processing has to be necessary. And so it's really a balancing test, and ensuring that there aren't any interests of those citizens or consumers that would override your legitimate interest as a business. Again, you have to record whatever is the test that you performed, the analysis, the balancing test, the factors that you determine to help you determine compliance. So if you are relying on legitimate interest as the legal basis for your processing, right, it needs to be documented, right? So it's not just oh yeah, we think we have a legitimate interest to process this type of personal data. You need to have this documented.
So what sort of system would you think would be at a minimal viable level that you would, is it a set of spreadsheets? Is it a software tracking platform?
I think at a minimum, it's a spreadsheet and it's some sort of memo documenting the analysis and that 3-part test, which maybe go to the, no,
Yeah.
I think it's the other way.
Isn't that the legitimate interest 3-part test there?
Yes.
There we go.
So this is sort of the high level, right? The pros and kind of cons. It's flexible. It's not centered around a particular purpose. The subject has not specifically agreed, right? So you're not going and getting consent. You're really, as an organization, you're doing the analysis yourself, right? So you're basically saying, hey, we think our legitimate interest in this processing activity really outweighs the need for the data subject to give clear consent. So it really applies to any type of processing activity. But again, the last bullet is that there's significant accountability on the controller, right? Because you're not getting the opt-in consent or a contractual consent from the individual.
Now, would that accountability probably include different segmentation of different groups of people in that interest? So you mentioned children earlier, but maybe people who are receiving financial benefit versus people who are not receiving financial benefit, or in a quasi-contractual relationship.
And in the future slides, we'll talk about where we think this is probably an appropriate basis and where it's not.
Great.
The next one I think is really an assessment. So you asked Mark, how do you document this, right? What I would be doing is walking through, again, I mentioned it was a 3-pronged test, and it really is taking this assessment and documenting this, right? So one, identifying your legitimate interest, right? And you need to document what that is. Is it legal? What's the specific activity? What's the value to you, right, as the controller? And then the next one is the necessity test. Again, is it proportional to, right, the legitimate interest? Are there alternatives, right? Could you easily go get consent, or is there a reason why consent or a contract doesn't work? And then it's just this balance, and how are you still safeguarding, right, the consumers and the citizens? Can you, or so it's really just documenting this, thinking through your analysis, and making sure that you have a record of it, which at a minimum would be, I think, just at least a memo. But you also need to ensure that your legitimate interests are documented in the privacy policy. So I've actually even started to see some privacy policies that specifically say we're relying on, right, our lawful basis for processing this data is based on our legitimate interests, right? Which means if you see that language in a privacy policy, you should know, right, that, right, they're not getting your consent. It's not contractual. They're just assuming they have a valid basis for processing that.
Interesting. Thank you.
This is just sort of a high level of, can you rely on it? What I would tell you, though, is just to understand, right, if you're getting an opt-in consent, you have the consent. The worst the regulators could say is somehow, it wasn't they want to change the consent language. Maybe you didn't document something appropriate in the privacy policy. If you're relying on legitimate interest, though, the regulators could come say, we don't think you have a legitimate interest at all, right? And it just goes away, right? So talking about the sanctions we talked about earlier, they can just completely undo this. So it's not, the regulators can't undo a consent. They can say maybe you didn't handle it appropriately, or you need to document it differently in your privacy policy. But the consent is the consent, right? If you have a contract, you have a contract. A legitimate interest, right, you run the risk that a regulator can come in and just say, yeah, you know what, you don't have a legitimate interest. You should have pursued another alternative, and now you're sort of out of luck.
Which is probably why the legitimate interest should be your end backstop before almost anything else, because then the agencies can be fairly capricious in what they're.
It's very subjective, right?
Yes.
Here I've kind of given you some guidance as to where areas that legitimate interest might apply from a business standpoint, right? If you're trying to prevent criminal acts, fraud prevention, public safety, network security, those are all, right? You really are protecting the interests of the citizens and the consumers. Areas for maybe, which I think is going to be a case-by-case basis, but I would tell you if you fall under the maybe category, I would tell you be careful, think about it. Have you, if you really are using legitimate interest, is there, again, right, have you thought about, in that three-prong test, have you thought about alternatives? And yeah, I would say if you're in the maybe category, it's not a sure thing. Marketing is, I think, a big topic of is a legitimate interest useful or appropriate in marketing? This is something I got from when I was at the IAPP conference, and I thought it was interesting, sort of thinking about the spectrum of marketing activities and whether or not legitimate interest is the right lawful basis to be relying upon. Obviously, this is subjective. It's not a one-stop shop, but I do, at least what I would encourage people to think about is, right, you really should look at all of the particular aspects of your marketing campaigns to determine what lawful basis you have for that processing activity. And again, if you're relying on legitimate interest, you better make sure that for each particular activity that you've documented that three-pronged test and you have it in your records.
And I think that, for the law firm people online here, I think adding this into your retention letter, getting consent for use of limited personal data of employees and that sort of stuff is certainly a best practice that I would push out to the audience as well. But again, I think that one size does not fit all in this world, and the more people try, the more inappropriate they tend to look when you get these things. So I think everyone should think deeply about what your processes are and how they should be changed in light of this.
So this is just because I'm going to compare and contrast consent and legitimate interest. But this is just a reminder for all of you, right? If you're going to rely on consent, just your lawful basis, you need all four elements. Right, freely given, specific, informed, unambiguous, right? So you need to have those for purposes of lawful consent.
And there's also a number of places where they're offering you the opportunity to consent, but there's no opportunity to not consent. And, one has to argue whether that's freely given or not.
I think this is sort of an interesting view, right? When you're thinking about it, for a legitimate interest, someone has the right to object after the fact, but you don't have the ability to withdraw your consent, right? Because if you've given your consent, you have subject access rights. You can actually go in, and every privacy policy should have a mechanism for how do you withdraw your consent. There is no such thing under legitimate interest, right? You could pick up the phone and call the company and say, I don't like this, but that's about it. The company, I was saying this earlier, the company has, if you've relied on legitimate interest, you have an opportunity to defend if the regulator comes knocking, and that's about it. And then you're left to whatever is the decision by the regulator. When you're dealing with consent, you're not dealing with the mechanism itself, you're just dealing with individual requests from the data subjects, right? So someone could withdraw consent. They could, it's different rules apply based on the type of legal basis. So unfortunately, it's an expectation test. It's a balancing test. There is no, Mark said earlier, there's no one answer, right? It's not a one-stop shop. What I did want to leave you with, though, is, right, as you're thinking about processing activities, right, post May 25th, the starting point should also always be, what is your lawful basis for processing that personal data? and just understanding as a starting point, right, that there's 6 ways of consent, of collecting or establishing that lawful basis. And if I leave you with nothing else, it's that if you're relying on the legitimate interest, make sure that make sure that you understand it's a really high bar to clear. And even if it says here, even for companies and organizations with the direct relationship with the citizen or the consumer, the expectation test will be interpreted much more strictly than many expect. And I can say that was very much a general consensus over in Europe. And if companies are going to, I think historically this has been something where clients have just said, no, we have a legitimate interest, that's what we're going to rely on. We all kind of went, okay, yeah, good, end of story, we'll move on. But just from a regulator standpoint, I will say, right, I continue to hear from the ICO and the DPAs over in Europe that, right, this is going to be a focus for them. Our companies are relying on legitimate interest for as a legal basis.
And I think that there's going to be a lot of smell test in this area,
Mm-hmm.
where someone is perceived to be cavalier with the private data of citizens, and especially since you have each of the authorities can pick and choose themselves. I think you have an opportunity for a lot of missteps by doing a full reliance upon legitimate interests. It's just not it's not a safe bet, I don't think, in any sense. So as Liz had mentioned earlier, use the different tests or the different interests other than consent as kind of a cascading filter to only use legitimate interest when you have nothing else you can use, and then really think really hard about that.
So my first bullet, it does help you avoid consent fatigue, right? A lot of us who have been managing consent and having to build a consent mechanism into our technology, right? It takes a lot of time and energy and effort. And like I said earlier, I've now gotten complaints because the consent wasn't translated, and there's a lot of work that goes into it. And legitimate interest may seem like an easy out, but I caution you because it is not as easy as one may think. There is more work compared to the other basis. You have to document your purpose. You have to demonstrate necessity. You have to justify, and you have to add additional clarity and detail in the privacy notice. So, right, again, I guess I highlight this, right? If you're relying on legitimate interest, make sure you're using those words and you're describing it in your privacy policy, and you have an objection handling process. There is a lot more scope for disagreement over the outcome of the balancing test. Again, you're like at the whim of the regulators if they don't agree with your test, and you better be prepared to prove that you're compliant. And the onus is on you as the controller if you're relying on this. So certainly this isn't to say that this isn't ever the appropriate lawful basis. In instances it will be, but just make sure that you understand the process if this is your basis.
Well, thank you, Liz. And like I said, I think we'll leave 5 or 6 minutes here for questions should anybody want to ask them. Again, just asking the audience in general, would you be interested in some other general series on the GDPR and how they kind of fit into the process? I think the designing privacy by design is I think a really interesting one from my standpoint, because especially when we're working with clients who are working in data software, there's an opportunity for a lot of benefits to be identified early on. Just because someone can do something doesn't mean under data privacy that you should or even are allowed to. We see that a lot in some of the databases. We have a question: will this presentation be available to us? Yes, it'll be a link sent out in a follow-up email, as well as the earlier email as well, the earlier presentation as well, which is a little more IP heavy. But what we're really trying to do here is provide good, useful things for how you think about your privacy and your technology and your IP going forward. So any follow-up comments, Liz?
No, just as a, I mean, this is just the starting point that I've touched on today. It really should be like step one of your analysis as you're thinking about processing activities in the future. The slide that had the bullets of all sort of ongoing obligations, once you've determined your lawful basis for processing, however you determine it, you then have a lot of ongoing obligations, which hopefully will attack some of those in future presentations. But just it's not a, this was not a you know, we get to May 25th and we're all good. This is, again, if this is about responsibility and accountability, this is an ongoing thing, and it's not a check the box. So to the extent you can really find ways, again, to inject this into your DNA, you're going to be better off as an organization versus just, I've heard a lot of people say, oh, I just updated GDPR, yep, I just updated my privacy policy and we're good, right? Privacy policy, and I'm working on my cookie policy and then I'm good, right? And I've got some sort of consent bucket, and there's a lot, GDPR's more than that. So I would just encourage you to embrace some of the other elements of GDPR as you're thinking about your obligations of as a, not only as a controller but also as a processor.
And for those of you out there who are, you know, either putative DPOs or the actual DPO of your corporation, Liz and I are both happy to chat with you offline. We're both available on LinkedIn. Reach out to us if you'd like to, and let us know kind of how you think that should be, you know, used.
Oh, there's another question.
There's another question. I can't quite read it. How does subscription to the public news articles fit in this whole scope? So if a customer clicks on subscribe, well, it you know, all depends on what is that person doing. If the person is, you know, if you're leaving a cookie on a person identifiable bit of information, that button click, I think it certainly falls into the scope. You know, there's yeses to that answer and there's no's to that answer. It's really going to be dependent upon if you click on a button and you're giving someone an email, and oh, by the way, when you click on the subscribe button, you're also loading a cookie that, you know, picks up your machine ID, you know, goes out and, you know, looks at the other cookies in your thing and makes some other judgments about you personally. You can get really, really deep into the GDPR if you're just, you know, collecting an email address. Maybe less so. So I mean,
which is generally not the case. Most of, you know, my company and others in sort of the space, I know that it's rarely just that. It's usually, you know, oh, I don't collect first name, last name, and then you say, no, but what else are we collecting based on that person, right? That hit, and it's, well, no, I have IP address, and I have a device identifier, and I have a cookie, and I have this sort of demographic data, and I have this user ID. It's not their first name, last name, but I have this very specific user ID. So you have to, it really becomes more of a conversation around really trying to figure out truly and pushing what kind of data really is being collected and processed, and doing right privacy impact assessments, because I think that's really what should be documented, right? And that's how you kind of figure out, right, when that person is clicking subscribe, what personal data, if any, is being collected, right? And
how many trackers, and
yep.
I mean, yeah, I think that you know, especially if you're a company that sets out newsletters or just, you know, white papers and whatnot on your even on your own website. You would be shocked at how many different trackers that whatever web hosting company or what web tracking companies that you've hired to do this work is actually got on there. I mean, over the course of a weekend, I got requests from well over 1,500 trackers just in a very limited usage over the weekend. So I hope that answers your question.
Yeah, I mean, and if you're the company wanting someone to subscribe, you also have to be thinking about, are you sharing that data with a third party, right?
Mm-hmm.
So are you collecting, So for example, someone is clicking subscribe and you also are getting a cookie and an IP address and some sort of device ID, and you're are you sharing that information with somebody else, another third party? And you also have to be thinking about, right, when you're thinking about your lawful basis, that's assuming you're collecting that or processing that personal data as a controller.
Yes.
Right, because it's the controller who is required to have a lawful basis. If you're collecting that as a processor on behalf of someone else, then you need to be sure that you have a written agreement in place with the controller and they're directing you to do whatever, whatever it is.
Yeah, and so like I said, as you can well see, we can talk about this for quite a long time on even small questions. So thank you for your time. We appreciate your attention. Again, both Liz and I are available for offline conversations, and thank you for your time.
Thank you.